Today is a normal Monday. Every Monday, there's funny and interesting lesson, which is the subject company law. Shuhan is sitting in the class, focusing on the lesson delivered by the lecturer. But he is confused about the topics separate legal entity and Turquand's rule. So, he decides to ask the lecturer after the lesson to get further clarification. However, he still feels upset after the class.
Hey bro, what's wrong with you?
I just finished my company law class, but I don't understand about separate legal entity and Turquand's rule.
Oh, separate legal entity is easy only. Let me explain to you.
The concept of a separate legal entity of the company is a basic principle of the law and that is applicable in most parts of the world. So, what's the meaning of a separate legal entity? Look at the definition. According to Companies Act 2016, Section 20, a company incorporated shall have legal personality separate from that of its members and continue in existence until it is removed from the register. In other words, a separate legal entity means a legal person. Legal because its creation is by law, and person because it has similar rights to a human being. When a business is registered as a company, the Act gives right and power and distinct personality to the company from shareholders. This means the company will be identified as an artificial person, because its creation is by a process other than natural birth. It is invisible, intangible, and exists only in the eyes of law. It is the special feature of a company which other forms of business do not have. So, why is a separate legal entity important? With the entity, a company, just like an individual person, may own a property in its own name. A company may borrow money from financial institutions or may also have a policy to lend money to the employees. A company is also able to enter into a contract with any third party, such as its suppliers, customers, or employees. With the status of a separate entity, the members cannot be sued, but the company can be sued for any legal action taken against the company. Similarly, the company is not liable to pay personal debts of the members. The company is only liable for its own debts. Thus, the company has limited liability either by shares or guarantee. Let's look at one example. R versus Arnold in 1846. In fact, the concept of separate legal entity originated from this case. A registering authority had refused to register a ship because some foreigners were among the owners of the ship. The ship was owned by a British charter company, but its members included some foreigners. The court ordered the registering authority to register the ship on the grounds that the owner of the ship was the British charter company rather than the members of the company. Nevertheless, the unanimous decision of the House of Lords in the Salomon case is regarded as a landmark in company law, which confirmed that a company is a separate legal entity with distinct personality. Now, we look at the case law, which is Makara versus Norton Assurance Company Limited 1925. Mr. Makara sold his timber estate to a company known as the Irish Canadian Saw Mills Limited, in which he was majority shareholder. Mr. Makara subsequently insured timber against fire. However, the insurance policy was in his own name, not the company. After 2 weeks, a fire broke out and he claimed the insurance. The insurance company, Norton Assurance Company Limited, argued that Mr. Makara did not have an insurable interest as a shareholder in the company. They argued that the company is a separate legal entity. The question is, Does Mr. Makara have an insurable interest? In the judgment, Mr. Makara could not enforce the contract of the insurance. He held no insurable interest in the timber. In other words, Mr. Makara was not liable on the contract, since the timber that perished in the fire did not belong to Mr. Makara, who held the insurance policy.
Okay, so now let's proceed with piercing or lifting the corporate veil. So as we know, in a separate legal entity, a corporation is treated as the separate legal person which is solely responsible for the debts it incurs, and the sole beneficiary of the credit is its owner. But in exceptional situations, may pierce or lift the corporate veil. So let's see what is corporate veil and the factors on leaving the veil. Okay, so the corporate veil is a term used to describe the separation of a business from its owners for liability purpose. So a corporation or limited liability company as a separate entity is set up to shield the owners or members of the corporation from personal liability for debts, ignorance, or mismanagement of the business. So a simple example would be here, where a businessman has left his job as a director and has signed a contract to not compete with the company he just left for a period of time. So if you set up a company which competes with a former company, technically it would be the company and not the person competing. Okay, next is the purpose of having the corporate veil. So the purpose of having this seal is to deal with the situation law leave the veil of incorporations, or to limit the liability of the firm owner. Okay, so now, after we know what is corporate veil, so we proceed with the factors on lifting the corporate veil. Okay, so the first issue is the existence of fraud, wrongdoing, or injustice to third parties. So it is the biggest red flag when determining whether or not to pierce the corporate veil. So in majority of the cases, the claimant is seeking to pierce the corporate veil because of the wrongdoing of the company or its owner. So, for example, we can see on the diagram, creditor of QW Crop received a final judgment for money damage. So QW Crop cannot pay the judgment, so it shut down. Then QW Crop transfers all its assets to Outright Crop, and Outright Crop operates a similar business with same asset and same employee. So in this example, it's likely that QW Crop engaged in the wrongful and potentially fraudulent actions by shutting down its business and reopening a new corporation of the same ilk. So this is a classic example of the debtor attempting to defraud its creditors and the creditors seeking to pierce the corporate veil. And secondly, the issue is the failure to maintain the separate identities of the company. So this scene can be seen when there are several related affiliates or multiple companies acting under the umbrella of one company, as the failure to maintain separate identities of the companies. So to narrow this issue more, let's use the example of when there is a parent company and a subsidiary company. So the parent company operates and controls the subsidiary, such as providing all financing and indicating the same employee. So the subsidiary can likely be assumed of being the alter ego of the parent company. So the third issue is the failure to maintain separate identities of the company and its owners or shareholders. So these circumstances may arise when the owners create a corporation or limited liability company but continue to operate out of individual checking accounts and fail to recognize corporate formalities and use the company's assets as if they were individual assets. Then we move on to the fourth issue, which is the failure to adequately capitalize the company. So these issues arise when an owner is not taking enough money or running a business haphazardly. So for this issue, first we'll look at the asset of the company to determine if the company levels of assets available to creditors is fair. So the last one is failure to follow corporate formalities. So the final issue is the failure to observe every corporate formality. So if formalities are not properly followed, courts have held that the legal liability protection of the shareholders was effectively waived and the personal assets of the owners could be reached by the claimant. Okay, so after finding out the factors, let us look at the example case that related to lifting the will, which is the Ocala Breeders Sales Company versus Hilliard Incorporations. So let's start with the background of the case. So Helia Parks is the wholly owned subsidiary of Helia Incorporations. So Helia Corporations operates the Helia Parks racetrack. So Helia Parks is in charge of non-race related activities at the racetrack, such as listing the facilities for wedding. So Helia Parks is a company that has never have an account and never been capitalized. So furthermore, Helia Parks transfer all receipts directly over to Helia Incorporations and never earn a profit. So after that, let's move to the case summary. So in 1984, Ocala Breeders entered into a lease with Helia Parks for the use of sale pavilion at the racetrack. Under the lease, Helia Park agreed to spend 1.5 million to renovate and refurbish the sales pavilion and other areas of the racetrack. So then, Helia Park failed to make the required improvement. As a result, Ocala Breeders filed suit and obtained the judgment against Helia Park. So when attempting to execute on its judgment, Ocala Breeders learned that Helia Park had no asset to satisfy the outstanding judgment. So as a result, Ocala Breeders seeking to hold Helia Incorporation liable for the judgment against its subsidiary, Helia Park. So in order to prove the corporate view, Ocala Breeders have provided undisputed facts in this case to show Helia Incorporation was liable for the judgment by giving the reason when both Helia Parks and Helia Incorporation were controlled by a same person. Besides, Helia Parks contracts were performed by the employee of Helia Incorporation. Furthermore, Helia Incorporation owned all of Helia Park's stocks. Moreover, Helia Park have never been capitalized and all funds earned by Helia Parks were directly deposited into Helia Incorporation's bank account, where Helia Park financial obligations were paid by checks drawn on Helia Incorporation's bank account, and Helia Park had no bank accounts. So, with the fact above, Ocala Breeders is able to claim for the judgment for Helia Incorporations and piercing Helia corporate view, since Helia failed to maintain separate legal entities as companies.
Oh, so that's all about separate legal entity. How about Turquand's rule?
Turquand's rule, I also confused about that.
Hey, Edwin! Can you explain Turquand's rule for us?
Yes, no problem.
Now we will be explaining Turquand's rule, or known as indoor management rule. Before we discuss Turquand's rule, I would like to introduce Doctrine of Constructive Notice, which was applicable in Companies Act 1965 but not Companies Act 2016. This doctrine stated that all persons dealing with a company are deemed to have knowledge of the company's Article of Association (AOA) and Memorandum of Association (MOA). It is a responsibility of the party entering into a contract to collect, read, and understand the documents. In a simpler word, the constructive notice means that notice was given even without an actual notice existing. For example, when a court is unable to direct reach someone and publishes a summons in the public newspaper, this is considered to be a constructive notice. So this kind of doctrine actually is harsh on the outsider who does business with a company, because the outsider cannot claim relief on the ground that he was unaware of the powers of the company in the case of ultra-virus of the companies. Hence, the Companies Act 1965 was repealed by the Companies Act 2016 on 31st January 2017. Under the Companies Act 2016, MOAs are no longer compulsory, and in view of Section 39, the doctrine of constructive notice no longer applies. So what is Section 39 about? Let's have a look at it together. Section 39 is not applicable of doctrine of constructive notice. It states that no person shall be deemed to have notice or knowledge of the contents of the Constitution or any other document relating to a company due to the fact that the Constitution or document has been registered by the registrar, or that is available for inspection at the register office of the company. However, there's exception of documents relating to instrument of charges. Now let's look at what is actually Turquand's rule or indoor management rule. Turquand's rule laid down to facilitate business dealing as a person dealing with a company in good faith is entitled to make certain assumptions about the regularity of the company's internal affairs. The outsider is also entitled to assume that there has been compliance with the AOA and bylaws of the company, and that the outsider need not question in the formularities of the internal proceeding of a company. In addition, Section 21 of Companies Act 2016 also provides that a company shall be capable of exercising all the functions of a body corporate and have the full capacity to carry on or undertake any business or activity. Therefore, third party can assume that the transaction is not ultra-virus. In short, Turquand's rule is a presumption of regularity. So why indoor management rule is known as Turquand's rule? Let's have a look at its origin. In 1856, there was a case between Royal British Bank and Mr. Turquand. Royal British Bank was the plaintiff while Mr. Turquand was the defendant. Firstly, it started with the Cameron's Coalbrook Steam, Coal and Swansea and Logger Railway Company had given a bond for £2,000 to the Royal British Bank, which secured the company's drawings on its current account. The bond was under the company's seal and signed by two directors and the secretary. However, after some time, the company became insolvent. Mr. Turquand was the liquidator of the company and he intended to evade the liability of the £2,000 bond. When the company was sued, it alleged that under its registered deed of settlement, directors only had power to borrow up to an amount authorized by a company resolution, and they claimed that there had been no resolution authorizing the making of the bond by two directors. In the end, the court decided that the bond was valid. Although the bank was deemed to be aware that the directors could borrow only up to the amount resolution allowed, and the articles of association were registered with Companies House, so there was constructive notice, but the bank could not be deemed to know which ordinary resolution passed because these were not registrable. Hence, there was no requirement to look into the company's internal workings, and this is the indoor management rule where the company's indoor affairs are the company's problem.
Turquand's rule originated from the case of Royal British Bank was also applied in Malaysia. The Federal Court in Malaysia discussed this Turquand's rule extensively in the case of Khai Holdings Sdn Bhd and Anna vs. Lee Lai Bian. In brief, this case explained whether an outsider who entered into an agreement with a former director is protected under the rule of Turquand. Now, let me explain further what is this case about. The first plaintiff, Khai Holdings Sdn Bhd, was the owner of two plots of land, namely Lot 2929 and Lot 2930. The second plaintiff, Khai Realty Sdn Bhd, was the owner of Lot 2980. The first defendant, Siwa, was a former director of both companies who ceased to be a director of Khai Holdings on 15 September 2008 and Khai Realty on 19 August 2009 respectively. Despite having ceased to be a director of the companies, Siwa engaged the second defendant, Lee Lai Bian, to extract earth from lots 2929, 2930, 2980 from May 2009. Siwa issued a letter to Lee and both parties subsequently entered into a 3-year tenancy agreement. In September 2010, a director of the companies informed Lee that Siwa had ceased to be the director and he was not authorized to perform transactions on behalf of the companies. In spite of this, Lee continued extracting earth from the lots up to December 2010. The companies subsequently brought a claim against Siwa and Lee for accounts and damages for fraud, forgery, trespass to land and conversion. Khai Holdings and Khai Realty claimed that Siwa had fraudulently held himself out as a director and manager of the companies and forged a letter which purported to engage Lee to extract and purchase red earth and rock materials from the lands. Second, Lee had known at all material times that Siwa was not an authorized representative of the companies. And third, Siwa had received monies from Lee as payment for the extraction which were below market value. Siwa, however, claimed that he was a director of Khai Holdings and had acted with authority. Lee, on the other hand, claimed that he relied on Siwa's representations and had lawfully extracted the earth as per the tenancy agreement. In turn, Lee advanced a counterclaim for loss of profits due to the breach of tenancy agreement. After a full trial, the High Court allowed the company's claim against both Siwa and Lee and dismissed the counterclaim. The court held that Siwa knew of his removal and that he was not authorized to act on behalf of the companies. As the tenancy agreement and letter issued by Siwa were invalid, Lee did not have the right to extract earth from the lots. Dissatisfied with the result, Siwa and Lee filed appeals against the decision of the High Court. After hearing submissions, the Court of Appeal affirmed the High Court decision on Siwa's liability as there was no appealable error. However, the decision on the Lee's liability was overturned as the Court of Appeal held that the High Court failed to fully appreciate the evidence before it and that Lee was entitled to invoke the Guan's rule. Dissatisfied, Shanghai Holdings and Shanghai Realty sought leave to appeal from the Federal Court. Federal Court held that in order to invoke the Guan's rule, the law imposes a minimum duty upon an outsider to perform the necessary checks, such as a land or company search. As Lee had not done so, the Federal Court found that the Court of Appeal had erred in allowing Lee to invoke the Guan's rule. If the necessary search were done, Lee would have easily discovered that Siwa was not a director of the companies and that he had no authority to enter into such a transaction. The Federal Court held that the doctrine of constructive notice was applicable to Form 49 as it fell within the definition of a public document. Further, it was held that the Guan's rule is inapplicable in instances whereby the representation of authority is made solely by a person with no authority. Consequently, the Federal Court allowed the company's appeal and held that Lee was not entitled to rely on the Guan's rule.
Nice.
The Turquand rule is also subject to certain exceptions. In other words, relief on the ground of the indoor management can be claimed by the outsider dealing with the company in the following circumstances. First, where the outsider has actual knowledge of the irregularity. When an outsider who is entering into a transaction with a company has constructive or actual notice of the irregularity in relation to the internal management of the company, then he or she cannot seek remedy under the rule. There can be some cases where the outsider is himself or herself a part of the internal procedure. Second, suspicion of irregularity. When the outsider suspects that an irregularity exists and ignores making the necessary inquiries, he or she cannot invoke this Turquand rule. This is because he or she had a chance to learn about the irregularity, but he or she voluntarily decided not to. Third, forgery. It is pertinent to note that the Turquand rule does not apply in cases where an outsider relies on a document which is forged in the name of the company. A company can never be held liable for the forgeries committed by its officer.
Hey guys, it looks like it's going to rain.
Yeah, let's take the bus back to college.